Well, good evening, everyone, and happy day after Constitution Day. I'm Anthony Johnstone. I get to teach constitutional law here at the University of Montana's Blewett School of Law. This all goes back to a amendment that Senator Byrd proposed of West Virginia, proposed and Congress enacted in the Consolidated Appropriations Act of 2005. I'm sure you're all familiar with this. You can read this with me, follow along. It was a rider to Section 106 of Title 36, of course. It said that each educational institution that receives federal funds for a fiscal year, it includes this one, thanks to all of the financial aid and grants and other things, shall hold an educational program on the United States Constitution on September 17th. That was Sunday, so I think we can get away with the 18th. Of such year for students served by the educational institution. Now, one of the ways we observe Constitution Day here at the University of Montana and the School of Law is we ask whether Constitution Day is itself constitutional. It might not be, surprise, but we won't go into that tonight. In fact, in Montana, we don't need a federal mandate to celebrate our constitutions, not just our U.S. Constitution, but our Montana Constitution, which will really be the subject of tonight's talk. Before I introduce our speaker tonight, I want to thank the Provost's Office, the lead sponsor of this event, including our Provost Beverly Edmond, Claudine Sellier, and Zoe Phelan for their support and organization of this. I'd like to thank our history colleague Mike Meyer for his support, and Kathy Reeves of the law school for her assistance, Dean Paul Kurgis for the law school support. And this year also we welcome the support of the Project on American Democracy and Citizenship here at the university, directed by our political science colleague Rob Saldin. I'd also like to thank our student chapters of the American Constitution Society and the American Civil Liberties Union, Ben Langford for putting on a student event earlier so some of our students could have a discussion, a more open discussion with our guests tonight. And of course, thank all of you from the School of Law across campus and the community for coming here to join us tonight. So I'd like to have the pleasure of introducing our speaker tonight. Caitlin Boardman is a Missoulian who has come home, which is a very good thing for Montana. She currently serves as the executive director of the ACLU of Montana, where she leads the organization's legal, policy, communications, fundraising, and administrative operations and programs. The ACLU of Montana is an affiliate of the National ACLU. It's an independent nonprofit organization that has over 5,000 members in Montana and works to protect the full range of liberties protected, not just by the U.S. Constitution, but also by the Montana Constitution. People interested in that, I'm sure as a good executive director, Caitlin Boardman is going to direct you to the website, but you can learn more about their work at aclumontana.org. Caitlin received her BA from Yale and her JD from New York University, where she was executive editor of the New York University Law Review. She clerked for Judge Robert Patterson of the Southern District of New York and worked as a litigator at Davis Polk and Wardwell in New York. Before returning to Montana, Caitlin had a long career as a law professor at the City University of New York School of Law and as a senior fellow at Columbia University Center for Gender and Sexuality Law. She was the state strategies coordinator at the Reproductive Freedom Project of the American Civil Liberties Union, the National. Her scholarship as a professor is focused on the respective roles and authority of the courts and legislatures in protecting constitutional rights and on the role of judicial treatment of fact-finding in constitutional rights cases. She has also written extensively about reproductive rights and has also brought that knowledge into the courtroom, where she's litigated a number of major reproductive rights cases. On a personal note, she has been a wonderful colleague all the way back to 7 years ago when I was standing here, and she was kind enough to attend the Constitution lecture that I gave in 2010, and that's where we first met. And constitutional law professors all over the country are indebted to the ACLU and their work because they give us so many of the cases we get to study. But I am particularly indebted for Caitlin coming home and doing her good work here in Montana and bringing all of her substantial knowledge and love of the Constitution to us here where we can benefit from it a little more directly. The title of Caitlin's lecture is Transgender Equality and the Constitutional Right to Dignity. Please join me in welcoming Caitlin Borgman.
Thank you so much, Anthony, and thank you to the Provost's Office and the Blewett School of Law for inviting me to talk here today. It's really awkward with this laptop and then my notes over here. Can you all hear me if I'm standing, not bending? Okay. The United States is seeing a wave of explicit anti-transgender animus expressed in the form of legislation, or in the case of President Trump's executive order barring transgender individuals from serving in the military, in the form of executive orders, banishing transgender individuals from full participation in public life. Montana itself is facing such a measure as we speak. It's a ballot initiative. I'll talk a little bit about that. What does the Montana Constitution say about this form of discrimination? Is it unconstitutional because it classifies on the basis of sex? Surely yes, but that answer doesn't begin to do justice to the harms transgender discrimination inflicts. And the Montana Constitution does not limit us to this answer. In fact, it compels a deeper analysis that is rooted in the principle of dignity that expressly undergirds our state's constitutional protections against discrimination. For those of you who might not be as familiar with what it means to be a transgender person, I just want to make sure that we're all on the same page with a few key terms. So a transgender person is simply one whose gender identity does not correspond with the sex that they were assigned at birth. That's in contrast to a cisgender person whose gender identity does correspond with the sex assigned at birth. Many transgender people seek to bring their bodies into alignment with their gender identity, and that's often referred to as transition or sometimes as gender affirmation. And it's important to know that gender identity is different from sexual orientation. Sexual orientation describes a person's enduring physical, romantic, and/or emotional attraction to another person, for example, being straight, gay, lesbian, or bisexual, whereas gender identity describes a person's internal personal sense of being a man or a woman, or being outside of the gender binary entirely. Discrimination against transgender persons has devastating effects. Studies have repeatedly shown higher risk of suicide among transgender persons. 40% of transgender adults reported having made a suicide attempt, compared with 4.6% of the general public. And often these suicide attempts occur at young ages. Suicide rates are influenced by outside stressors. Studies suggest that negative experiences related to anti-transgender bias contribute to the elevated presence of suicide attempts among transgender people. These stressors that affect transgender people include societal transphobia, which can then lead to internalized transphobia, family rejection, lack of social support, physical violence, and discrimination in healthcare, employment, accommodations, housing. Also, lest one think that transgender people have high suicide rates and experiences of emotional distress due to just simply to being transgender, studies have shown that each episode of victimization, such as physical or verbal harassment or abuse, increases the likelihood of self-harming behavior by 2.5 times on average. And studies have also shown that being seen as transgender is itself a stressor because of the discrimination that causes. So people who have had access to surgery that allows them to pass as cisgender, such as facial feminization surgery, for example, report improved mental health related quality of life close to that of the general population. Transgender people, as I mentioned, experience high rates of being subject to violence, including murder. That's particularly true of trans women of color. I mentioned recent legislative attempts to banish transgender people from public life. And I'm going to refer to the most prevalent form that we've seen as bathroom panic legislation. This kind of legislation prohibits transgender people from using restrooms and sometimes locker rooms and other facilities where people may present in some form of undress in accordance with their gender identity. They're forced to use the facility that corresponds to the sex assigned at birth, or in some cases to use a separate unisex single-person facility. One such bill was defeated in the Montana House Judiciary Committee this past session. Currently, the Montana Family Foundation is gathering signatures to put on a measure called I-183 that is a similar bathroom panic legislation to put it on the ballot next year. There are a lot of problems with these kinds of measures beyond discrimination that I'm not going to be getting into in the interest of time. Campaigns against non-discrimination ordinances that protect transgender people, among others, from discrimination, or for bathroom panic legislation have been characterized by serious misunderstandings of what it means to be transgender and ugly vitriol. When Houston passed a non-discrimination ordinance, there was then a campaign to repeal that ordinance. It was a successful campaign, and one of the ads in that campaign was characteristic. It said, "This ordinance will allow men to freely go into women's bathrooms, locker rooms, and showers. That is filthy, that is disgusting, and that is unsafe." The hysterical claims that non-discrimination ordinances would permit men to enter into women's restrooms perpetuates the hurtful idea that transgender women are not women. Bathroom panic didn't originate with the recent backlash against non-discrimination ordinances. As one commentator puts it, for more than 100 years, Americans have projected their most profound fears about social change onto public restrooms. Bathroom panic has historically been used to oppress, shame, and keep certain groups locked out of full participation in society. Bathrooms were among the racially segregated public accommodations enforced by the Jim Crow laws, fueled by mythology about black men's hypersexuality and black women's greater tendency to be suffering from sexually transmitted diseases. Phyllis Schlafly, the John Birch Society, and others stoked panic about the frightening specter of unisex bathrooms in a successful battle against the Equal Rights Amendment. So for those of you who don't personally know a transgender person, or perhaps just don't realize that you personally know a transgender person, I would like to introduce you to someone. This is Gavin Grimm. Gavin Grimm is a teenager and an ACLU client from Virginia who transitioned to being male while in high school. Gavin informed his principal at the time that he was planning to transition to being male and received support from the school. He began using the boys' restroom and used it for about 7 weeks without incident from any of the students, But some parents found out about it and informed the school board, and the school board had a problem with it and required him to go use a unisex bathroom, single bathroom in the nurse's office. In November of 2014, Gavin Grimm spoke to his school board to plead for respect. With incredible poise and determination, Gavin stood up for himself as a room full of people debated his body, some calling him a young lady, a freak, or likening him to a person who seeks to urinate on fire hydrants because he thinks he is a dog. Gavin said, "All I want to do is be a normal child and use the restroom in peace, and I've had no problems from students to do that, only from adults. I didn't ask to be this way, and it's one of the most difficult things anyone can face. I am just a human. I'm just a boy." Under the Obama administration, the Departments of Education and the Department of Justice issued a guidance letter that declared, quote, "to treat a student's gender identity as the student's sex for purposes of Title IX and its implementing regulations, that schools must treat a student's gender identity as the student's sex under Title IX. This means that a school must not treat a transgender student differently from the way it treats other students of the same gender identity. Gavin Grimm challenged his treatment by the school board in federal court, relying on this guidance. The district court dismissed his Title IX claim and denied his request for a preliminary injunction, and the Fourth Circuit reversed, siding with Gavin and deferring to the Department of Education and Department of Justice's guidance. Its interpretation that Title IX bars gender discrimination as part of its prohibition on sex discrimination. The school board then appealed to the Supreme Court, and that case was pending when President Trump took office. Under his administration, the guidance was rescinded, and the Supreme Court sent the case back to the Fourth Circuit. The Fourth Circuit then issued an order granting an unopposed motion to vacate the district court's preliminary injunction. But Senior Judge Andre Davis, shown here, joined by Judge Henry Floyd, issued a concurrence in which he said that Gavin Grimm stands alongside brave individuals who refuse to accept quietly the injustices that were perpetrated against them. And he put him in the class of individuals like Dred Scott, Fred Korematsu, Linda Brown, Mildred and Richard Loving, Edie Windsor, and Jim Obergefell. What do these individuals have in common? What is it about their courageous battles that aligns them with Gavin Grimm and others like him? Judge Davis saw that the common thread in discrimination based on race, sexual orientation, and gender identity is an affront to human dignity. And dignity is not implicated every time a person is treated unequally. As Judge Davis wrote, Gavin Grimm's case is about much more than bathrooms. It's about a boy asking his school to treat him just like any other boy. It's about protecting the rights of transgender people in public spaces and not forcing them to exist on the margins. Judge Davis's insights identify the core of the harm transgender discrimination causes in a way that federal decisions on discrimination, as well as Montana Supreme Court decisions on equal protection, generally have not. Not meaning to imply that the Montana Supreme Court has issued decisions on transgender discrimination, but they have not identified these general harms of dignity that I'll describe further in connection with equal protection law. Equal protection law has had a hard time articulating the distinct harms that discrimination causes when directed against a group that has historically suffered oppression. Courts refer to things like arbitrary classification, suspect classification, sometimes when there isn't no such classification, a bare desire to harm a politically unpopular group. We know that most legislative classifications are not wholly arbitrary. And so when the court wants to get at that, then it talks about suspect classifications. Sometimes that list doesn't encompass the discrimination at issue, but surely some desires to target a particularly unpopular group are okay. What if we're talking about vandals or litterers, for example? And equal protection case law too often relies mechanically on tiers of scrutiny without attention to the human suffering that certain kinds of discrimination can cause. The Montana Supreme Court's decision in Snetzinger versus Montana University System in 2004 is an example of this. In that case, the court held unconstitutional the Montana University System's policy prohibiting gay employees from receiving insurance coverage for their same-sex domestic partners. That was an important outcome, absolutely. But the decision, when you read it, looks sort of sterile. The conclusions are sort of pat. The court applied rational basis, so it was able to avoid the question of what level of classification was appropriate. It just applied the lowest level. One can certainly imagine reasons why the court might have done that, but from another perspective, it was a missed opportunity to apply an interpretation of the Montana Equal Protection Clause more consistent with its location within the dignity provision of our Constitution. I'll talk more about that in a minute. Federal cases specifically addressing transgender discrimination have likewise failed to give due attention to the way in which such discrimination amounts to an affront to dignity. Some federal courts have interpreted transgender discrimination to be a form of sex discrimination, relying on case law establishing that sex stereotyping is unconstitutional. Since Price Waterhouse versus Hopkins, discrimination on the basis of transgender identity has been recognized as discrimination because of sex in the 9th, 6th, and 11th circuits and by the EEOC. This is correct. It should be characterized as sex discrimination, but these cases don't go far enough. The problem is that sex stereotyping can go both ways. Males can be denied jobs as nurses. Ruth Bader Ginsburg famously relied on the strategy of using men as plaintiffs in early sex discrimination cases. A mere classification is not sufficient to qualify as an affront to dignity, however. A classification suffered by women who since time immemorial have suffered male oppression, rejection of their intelligence, their strength, even their sanity as reasons to deny them equal participation in society is not qualitatively the same as a male being denied a stereotypically female job. So in the case of transgender discrimination, it's not just the fact of being subjected to a classification based on sex that's the problem. It's not even the sex stereotyping. It's the way that society has chosen to ridicule, humiliate, and vilify in order ultimately to justify isolation and ostracizing. As one commentator notes, when transgender individuals are barred from using restrooms that match who they are essentially closed off from participating in public life. So to get back to the two insights in Judge Davis's opinion, core dignity being at issue and forcing people to exist on the margins. The US Supreme Court seemed poised to recognize the link between dignity and equal protection in Brown versus Board of Education. But it has since moved toward a more technical anti-classification approach to discrimination in most cases, especially in its race discrimination cases, as exemplified by the court's decision in Loving versus Virginia. So Brown versus Board of Education, for the non-law students in the audience and lawyers, and perhaps younger members of the audience, is the case that in which the Supreme Court declared racial segregation in public schools to be unconstitutional. So this is more of the sort of flavor of the Loving versus Virginia opinion. Bruce Ackerman, in describing the differences between the Brown v. Board of Education opinion and the Loving versus Virginia approach, which is the approach that has prevailed, talks about the concept of institutionalized humiliation. And this is how he defines it. So the idea being obviously not that victims willingly acquiesce or choose to acquiesce, but that they participate in this effort, they're forced to, right, by attending a racially segregated school, for example, or using a bathroom that's not aligned with their gender identity. The court's opinion in Brown relied on recognizing the institutional humiliation inherent in racial segregation. It saw that racial segregation was a badge of inferiority imposed by society rather than a figment of Black persons' imagination, as the court had suggested in Plessy versus Ferguson, the decision that supported separate but equal public accommodations based on race. This recognition of institutional humiliation as inherent in racial segregation was prevalent in the civil rights era. In Loving versus Virginia, aside from two solitary and unexplored references to white supremacy, the court does not discuss the institutional humiliation caused by anti-miscegenation laws. So Loving versus Virginia being the decision that held that bans on interracial marriage were unconstitutional. It recognizes that racial discrimination merits strict scrutiny without discussing or acknowledging the special humiliation that Mildred, as distinct from Richard, must have endured. Painful as the law surely was to Richard, it was, after all, Mildred's Blackness that in the eyes of the state deemed her unworthy of marrying a white man, that deemed their union an abomination. Daryl Hutchinson explains the problem with the strict anti-classification approach as it's developed. He says, once the court finds that a vulnerable group constitutes a suspect class, the analysis shifts from classes to classifications. Thus, any racial or sex classification is constitutionally suspect, although only persons of color and women, not whites or men, constitute protected classes. A strict anti-classification approach risks a hollow concept of dignity under which, as Chief Justice Roberts stated in a decision rejecting voluntary school integration efforts in Seattle, any classification under a state-mandated racial label is inconsistent with the dignity of individuals in our society. At its most absurd, that kind of approach leads to this. Have you all read about this quiz from Facebook that basically was used to train its censors to determine what kinds of hate speech to delete? And the reason that white men, I don't know if you can see this, but so it says, which of the below subsets do we protect? Female drivers, black children, white men. And the answer is white men. For reasons I won't elaborate on in terms of the algorithm, but the point being that because gender and race were protected classes, white men were protected, and in fact the others were not, because they had these other subclasses that were not protected, drivers and children. That's the short explanation. Kenji Yoshino applauds Bruce Ackerman's focus on institutional humiliation and expands upon its tie to dignity. Institutional humiliation is an attack on a person's dignity. Particularly in its race discrimination cases, though, the Supreme Court has moved away from Brown's focus on dignity. It has robustly incorporated dignity into its analysis in cases addressing the rights of gay, lesbian, and bisexual persons, although it has done so without formally recognizing sexual orientation as a suspect class, and has not always done so in the context of equal protection. In United States versus Windsor, the court held that restricting federal interpretations of marriage and spouse in the Defense of Marriage Act to apply only to opposite-sex unions was unconstitutional. Justice Kennedy's majority opinion in Windsor mentioned dignity nearly a dozen times. Dignity also played a central role in the court's decision in Obergefell versus Hodges, which invalidated bans on same-sex marriage. Montana's constitution expressly invites consideration of dignity when analyzing an equal protection claim. So in this talk, I'm not talking about a freestanding right to dignity, although such a right, I think, is defensible under the Montana Constitution and could well apply to bathroom panic laws as an independent claim. The Montana Supreme Court has repeatedly held that Montana's Equal Protection Clause provides broader coverage of the right to equal treatment than the US Constitution, but it has never really explained how. And its equal protections have not so far incorporated dignity into the analysis, although it has applied dignity as a sort of overlay on other rights, including the right against cruel and unusual punishment. And Justice Jim Nelson has repeatedly and eloquently, in concurrences and dissents, argued for a freestanding right to dignity. Dignity and the anti-humiliation principle are fully at play in bathroom panic legislation. Again, Kenji Yoshino. Gay rights have always been plagued by a politics of shame. This applies with full force to transgender rights. Courts may be reluctant to apply the Montana Dignity Law because of the potentially open-ended or subjective nature of that term. Matthew Clifford and Tom Huff have offered a careful analysis of the meaning and scope of the Montana Dignity Clause, including how it may inform the Equal Protection Clause. In addition, Naomi Rao provides a helpful taxonomy of dignity in American law. So I'm going to describe these three forms of dignity as she does. So inherent dignity exists merely by the virtue of a person's humanity. It doesn't depend on things like intelligence, morality, or social status. And it does not establish an external measure for what counts as being dignified or worthy of respect. In constitutional law decisions, especially in the United States, intrinsic dignity is reflected in decisions about freedom from interference by the state, so negative rights, you might think of them as, such as freedom of speech, privacy, and in sexual relationships. Substantive dignity is a concept of dignity that it can express and serve as grounds for enforcing substantive values. Unlike intrinsic dignity, substantive forms require living in a certain way, for example, when France bans the wearing of a burqa in public. Positive or substantive conceptions of dignity are also associated with social welfare rights or protection by the state from poverty and violence. In this understanding, dignity demands that the government provide the basic conditions of well-being. And finally, dignity as recognition is rooted in a conception of the self as constituted by the broader community. A person's identity and worth depend on his relationship to society, which requires individuals to demonstrate respect and concern for each other. What matters is not just having a space of interference for one's inherent dignity or living life with a particular dignity, but rather the attitude possessed by others and the state towards oneself. I find that the first and the third of these concepts of dignity, which are most prevalent in US law and state and federal case law in the US, are often conflated. They are distinct though. Inherent dignity is possessed by every person, and as I said, it's not contingent on outside factors. A person can't lose their inherent dignity. And because of their inherent dignity, the government's prohibited from denying all persons, right, certain rights, including free speech. The third form of dignity, dignity as recognition, relies on a person's being welcomed as a participant in public life, accepted as a member of society. This form of dignity is contingent on public recognition. So under this view, a person's dignity can be taken from them by certain government actions. Inherent dignity is always implicated in claims of constitutional or in claims of dignity that should merit constitutional protection, but unless the second or third forms are implicated, the constitutional right to dignity isn't at issue. We wouldn't say, for example, that a neo-Nazi's right to dignity is violated if a state infringes his constitutional right to free speech. Denial of public accommodations to historically oppressed and marginalized groups implicates the first and third concepts of dignity. Some state and lower federal court opinions have set forth factors for determining what level of scrutiny a particular class should get, or a discrimination against a particular class should get, or whether discrimination targets a suspect class. And these indirectly point to the third concept of dignity, dignity as recognition, by looking to any history of discrimination against the targeted class. In Montana, subjecting discrimination of oppressed and marginalized groups to strict scrutiny is expressly justified, if not dictated, by the placement of our Equal Protection Clause within the framework of dignity. Other potential consequences of relying on dignity to inform equal protection analysis could be used to explain why bare assertions of discrimination based on a given classification, such as race, should not always merit strict scrutiny. Affirmative action is one example. When a white person claims that an affirmative action program has discriminated against her based on her race, the third form of dignity is not implicated. White people have not historically suffered exclusions from full participation in public life. But that is beyond the scope of the topic I'm addressing here. In the case of transgender discrimination and public accommodations, both the first and the third concepts of dignity are implicated, and the case for applying strict scrutiny is at its strongest. Applying a dignity-infused approach to equal protection in the context of transgender discrimination would yield this adaptation of the court's statement in Brown. It would allow courts to focus on the human cost of discrimination against transgender persons. Case outcomes are important, but where discrimination involves public shunning, banishment from participation in public life, a court's infusion of dignity into that analysis can itself serve to recognize to say to transgender people, this court sees you and recognizes you as a full member of society, and our Constitution demands that the public recognize you as well. Judge Andre Davis saw how important it was that he recognized through the formal means of an opinion the school board's attack on Gavin Grimm's dignity, the way that it forced him to exist at the margins of public life. The Montana Constitution not only allows for this infusion of dignity into our Equal Protection Clause, it demands it. Thank you. Questions or comments? Yes.
So you were in a challenge before the state Supreme Court that they might kind of deflect and not embrace this full insensitivity and go more to a right to privacy and things that don't get into kind of the dignity of the person, but much more the nature of the state action. And if so, like how do you imagine getting the focus on dignity as opposed to just privacy?
Right. Well, I think yes, that is definitely a distinct possibility, especially in its equal protection decisions. And I think that the analysis there could look very similar to what it looks like on the federal level in Title VII cases, for example, where the court says this is sex discrimination. And you can make a really good argument for why this is sex discrimination. So that's not a terrible outcome. I just think that, you know, the court is moving, the Supreme Court is moving, the US Supreme Court is moving in this direction in its decisions on same-sex marriages, same-sex intimacy, but it's sort of constrained by this strict anti-classification approach, and so it's forced to put it into these classes, and it doesn't have a class for sexual orientation, and it certainly doesn't have a class for for gender identity, and so I think that what I'm trying to say here is that the Montana Constitution not only doesn't have those constraints, it's telling us to read our Equal Protection Clause within the context of dignity. And I think the best way of doing that is to get the court hopefully to understand the human stories behind this discrimination and hope that the court goes there. I don't think it's a stretch, especially given the way it's used dignity to inform other provisions of the Constitution. Thanks. Everyone's tired after dinner. Yeah.
So is it a little ironic that the dignity doesn't do its work until society shuns or excludes someone? I just wonder if dignity is, when you deal with the recognition, that dignity is focused completely on not what that person is, but on what others, what we should, dignity demands of others to recognize them.
Right.
Is that an irony we should worry about? Or?
I'm not sure I see the irony. I mean, that's the distinction between, that's why it's the third form of dignity, which is, this idea that this state can do something that deprives you of your dignity. Right, so if people are not being denied public accommodations, then their right to dignity isn't being violated. But there are things that the state can do that basically shun people, banish them, and racial segregation and bathroom panic legislation are two forms of that. Yeah.
Do you have any thoughts? When you mentioned Title IX, the part that gets in the news the most is sports. Do you have any thoughts on how to deal with transgender and hormone supplements generally in the context of participation in sports?
That's a great question, and I'm not fully up to speed on this case law, but I do know that that I'm not sure if this is a guidance from the federal government, but that I remember reading somewhere some guidance telling schools that they needed to allow participation in sports based on gender identity, and that for the most part, that doesn't cause as many problems as people anticipate. Certainly, I think there are examples perhaps on the margins, especially if, testosterone is being taken by a transgender. Well, actually, right, that I think that probably isn't a case where there would be unfairness, right? If a transgender male is taking testosterone, that's unlikely to pose an unfairness to other males. So I think generally that tends to be imagined to be a bigger issue than it has played out to be.
Are there tests that show who a transgender person is? Like on the reservation, there used to be, almost anybody could be on the rolls, but then they decided, no, you have to be 25% tribal in order to be on the tribal roll. And is there anything like that for transgender people? Or is it just, if I say I'm transgender, then I am?
Well, I think I should preface that by saying that's what it should be. If a person is telling someone that that's their gender identity and that's how they're living their life as a male or a female, then we should respect that. So we shouldn't require a particular test for someone to have to prove what their gender identity is. Having said that, there are, Gavin Grimm, for example, was diagnosed with gender dysphoria, and that is a diagnosis that psychologists can give. So that's a test, so to speak. I don't think it should be required of people to take that to prove their identity, though. Yes.
Is the second kind of dignity entirely irrelevant to transgender discrimination, or does it come into play marginally in some way?
Yeah, I think that the second kind of dignity is much less commonly seen in US law, much more commonly seen in international human rights documents and in other countries. But I think it's intriguing to think about this, and I wasn't exploring this as part of this topic, but given that we do have rights to a clean, health, and healthful environment, for example, or educational rights that aren't found in the U.S. Constitution, in the Montana Constitution. But sometimes these substantive conceptions of dignity can be very counter to, sort of our American system of rights. For example, the example of France barring wearing of the burqa, even though it's, we would consider that to be a violation of religious liberty. So I think it's potentially problematic and can be just as well used to constrain people's rights and liberties in ways that we in the U.S. would consider to be constraining of people's rights and liberties than to be beneficial to promoting those. I'm sorry.
What advice would you give to people who want to advocate against the bathroom canning bill that they're trying to get on the ballot in the next year or so? Like, what should we be taking actions now and then later in the future if things do go sour and they get all the signatures and then it's on the ballot?
Yeah, great question. So now I'm jumping out of my scholarly mode and into my ACLU advocacy mode. So the ACLU has already filed one challenge to the initiative, which is not going to keep it off the ballot, but it's a challenge asking the court to declare that the description of the ballot initiative that appears on the ballot is constitutionally insufficient because it doesn't accurately describe what's actually the initiative is doing. We will definitely be filing substantive challenges to this as well. In the meantime, signatures are being collected. I don't know exactly what happens if the description has to be rewritten. One would think that signatures should have to start over. And unfortunately, I don't, or maybe other lawyers in the room know the answer to that. But in any event, there will be a big vote no on I-183 campaign that the ACLU and our coalition partners are already in the planning stages of. I think it's really important to advocate against this as you would against, I think public advocacy against this is really important, not just by nonprofit groups, but by members of the public. And I think, starting to talk about it now is really important. But as we get closer, the groups will definitely have many opportunities for volunteering on this, and I hope you'll contact one of the coalition groups, and we'll get you plugged in. Thanks. All right, well, thank you so much for your interest and for attending, and I really appreciate it.